بسم الله الحمد لله والصلاة والسلام على رسول الله وعلى آله وصحبه ومن والاه. Carry on. So today, inshallah, we will go over two maxims. I think I sent them. I hope I sent them. الاجتهاد لا ينقد بمثله. Okay. الاجتهاد لا ينقد بمثله والخروج من الخلاف مستحب. الاجتهاد لا ينقد بمثله. اجتهاد is not annulled by اجتهاد, by its like, by اجتهاد like it. And الخروج من الخلاف مستحب, which means exiting from disagreement is recommended. Exiting from disagreement is recommended. And it may be too literal, I don't know, but like if there is like a better expression, let me know afterwards. So ijtihad is not annulled by ijtihad. Is like a very important qaida, like an extremely important qaida, that we do not void the ijtihad by ijtihad. Otherwise, there will be no stability in rulings. There will be no stability in the judiciary, in the Muslim judiciary. And you know, this particular qaida is an enormous sign of maturity and civility. That our ummah knew that Sharia, as ordained by God, is one. However, the understanding of what was ordained by God varies greatly. Therefore, it is Sharia according to. There is Sharia according to. Like last week, I was having. Was it last week? I was at Masjid al-Tawheed and we were discussing marriage and how to make marriage easy and what is making people afraid of marriage, frightened of marriage, young people, whether they are men or women, frightened of marriage. And I said part of it is the unpredictability. It's fear from the unknown. And because there is no coherent Muslim culture in America, really, there is nothing, close to that. Yet, hopefully one day there will be. If you grew up in Egypt 200 years ago, in a village in Egypt 200 years ago, keep in mind, it's also reductionist to think that all Egyptians have one culture, and Pakistanis have one culture, Egyptians have one culture. That's reductionist. But if you grew up in the same village in Egypt 200 years ago, it is very, very likely that you will wake up the first day after, like your wedding day. Everybody knows what is gonna happen. Everybody, like it's like a script. Everybody's reading from the same script because there is not diversity of cultures. It is just one culture, one tradition, one way of doing things, and that predictability is very useful for marriage. But when you have people coming, like in America, that come from different countries, different ethnicities, different backgrounds, different orientations, they belong to different madhahib, different approaches to the religion, and different understandings of the religion, even within the same madhab. You have people that are more conservative, people that are less conservative, people have different, even it's not just the spectrum of conservatism, it's just different approaches, different understandings altogether at many, many levels. And then, so I said to them, if you say to yourself, we'll just live by the Sharia, abide by the Sharia, you want to figure out which Sharia. And it may be startling and shocking, the Sharia is Sharia. No, Sharia is Sharia before God. God knows what he meant. But since we're basically fallible beings trying to read and understand what God meant, we ended up having different understandings in many issues. Like, is a woman expected to serve her husband? You don't want to figure this out after the first day, like after the wedding. Wait a second, this is that important or not? And if we will say we'll live by the Sharia, well, the Sharia will not give you one answer here. The Sharia will give you more than one answer. And then you have to figure out if you have a husband who is working 2 jobs and a woman who is staying home and she doesn't have kids yet, will he be expected to serve himself after he comes back home? And she will be surfing the net all day long, and like, what if the woman is working as well and contributing to the expenses of the family, and she, like, in addition to all of this, has 2 or 3 kids? Is that the same arrangement? Should he be expected, should she be expected to be doing all the work at home if she is working outside and contributing to the expenses and having 2 kids? Is she also expected, is she like that other woman? Of course not. So then a discussion like this will require what? You will have to have this discussion early on, before you get contracted. Not on your wedding day, before you get contracted. So, such a discussion will have. Can a husband force his wife to follow his madhab? You don't have disagreements about this between the madhab only. Within the Hanbali madhab, our madhab, there is an intra-madhabi disagreement over this very issue. So is this relevant? Is this consequential? Of course it is relevant and consequential. Should you be discussing this? Yes. Therefore, you have to understand that the Sharia revealed by God is one, interpretation is not. So there is Sharia according to the Hanafi madhab, and it's not only that. According to the mu'tamad of the Hanafi madhab, the authorized view in the Hanafi madhab, which they can disagree over at times, which Hanafis are determining the mu'tamad now. Are these the Hanafis of Sham or the Hanafis of India? Because they can disagree over the mu'tamad, because they're reading from different books. And their sort of highest authority in terms of references may differ sometimes. You do not want to be surprised. You do not want to be saying, well, just Sharia, will live by the Sharia, and then we will ask the Sheikh. Which Sheikh? Which Imam? Which Masjid? Which Islamic center? So it is vital that we understand that the Sharia is one, the interpretations differ. Now, when the interpretations differ, this is called ijtihad. Ijtihad. Ijtihad is basically, it comes from juhd, from effort, when you exert your maximum effort in pursuing the intent of the legislator. I want to basically arrive at the intent, the divine intent in this legislation. What did Allah mean? What did Allah want of us? What is the demand here of the Sharia? And, so your interpretation, my interpretation, this is my ijtihad, this is your ijtihad. Of course, we're talking about qualified people making ijtihad here. So then, should we abrogate, annul, nullify, void the ijtihad by ijtihad? They said ijtihad is not voided by another ijtihad. And this is the expression of al-Qadi Abu Ya'la in his book Al-Udda. When did al-Qadi Abu Ya'la die? 458. So we're not talking about modernist people or anything here. And Umar ibn al-Khattab radiallahu anhu adjudicated the same case twice differently. Which case? The case that we call al-Himariyya, al-Hajariyya, al-Yammiyya, whatever. We have different names for it depending on expressions of the Sahaba radwanullahi alayhim. So if a woman dies and leaves behind a husband, a mother, uterine siblings, and full siblings. Okay, husband, mother, uterine siblings and full sibs. What does the husband get here? What does the husband get in general? 1/2 or 1/4? When does the husband get 1/2 if she doesn't have children? Does she have children? What does the husband get? Okay. What does the mother get? 1/3 or 1/6? Huh? When does the mother get 1/6? If there are children or the multiplicity of siblings, do we have, what do we have here? Multiplicity of siblings. Okay. So what do the uterine brothers get? What does one of them get? What does one uterine brother get? 1/6. What do they get together if there are more than one? Huh? 1/3. What is that now? That is, huh? That's the whole inheritance. Okay. So what is left for the full brothers? Nothing. Okay. Now, keep in mind, in our madhab, this is it. The full brothers will not get anything. The full brothers will not get anything. Okay. And this is how I adjudicated this case the first time. The full brothers don't get anything. Full siblings don't get anything. And then Zayd ibn Thabit, you know, the full siblings and Zayd ibn Thabit, people started to argue about it. You know, we share the same mother. Like, okay, what is the difference between us and the uterine siblings? Us and the uterine siblings share the same mother with the deceased. In addition to sharing the same mother with the deceased, we, the full siblings, share the same father as well. In addition, we share the same father as well. Suppose that our father is a donkey, is a rock, and, you know, throw it in the ocean. Throw it. Like, he's nothing. Don't consider our father. Don't give us any advantage over our uterine brothers and sisters because of our father, because we share the same father with the deceased. Suppose he was a donkey, a rock, throw him away and just allow us to be like them. To be like them. And Umar, the second time this was adjudicated by him, Umar said what? Umar said, yeah, that makes sense. Let's do it this way. And then some people came and said to him, the first time you adjudicated this case, you didn't give them anything. And what did he say? تلك على ما قضينا يومئذ وهذه على ما قضينا. You know, people try, that is how he said it, but people say تلك على ما قضينا يومئذ وهذه على ما نقضي اليوم. To make it like sound a little bit better. That first case, you know, remains upon our judgment on that day. It remains. We're not going to basically void our ijtihad and redistribute the first case. It remains. That's it. The full siblings didn't get anything. It remains. But this particular case remains according to what we adjudicate today. They are the same case. But when we adjudicated the first case, we had a different ijtihad. Our first ijtihad will not be voided by our second ijtihad. And ever since, this has been the case. And if you look at how the Khulafa al-Rashidun had different ijtihads among themselves, and they did not void each other's ijtihad, that establishes that rule. Ijtihad cannot be voided by another ijtihad, except in certain cases that we will discuss, inshallah, later. So when we talk about ijtihad in this case, what do we mean by ijtihad? Do we mean the ijtihad in the technical sense, or do we mean the ijtihad in the wider sense? Both. Because of course, ijtihad in the technical sense is what Umar did, radiallahu anhu. Ijtihad in the wider sense is the ijtihad that will not cease until the day of judgment. What is the ijtihad that will not cease until the day of judgment? Remember our talk about tahqiq al-manat, ascertainment of operative cause. And we said there are two layers of ascertainment of operative cause. There is tahqiq al-manat fil anwa' and tahqiq al-manat fil a'yan, ascertaining the operative cause in kinds and in individual cases. we said what? That we have to figure out, if hashish has the operative cause of tahrim al-khamr, of the prohibition of khamr. If marijuana has the same operative cause in the operative cause of prohibition that is present in khamr. This is tahqiq al-manat fi al-anwa' in kinds. Now, this particular substance, does it have it? It's marijuana, but THC was taken out or whatever. So this particular thing here, does it have it? This is tahqiq al-manat in a'yan, in individual cases. And then we said that tahqiq al-manat in a'yan will not cease until the day of judgment, right? There is a third level of tahqiq al-manat that's a little bit more nuanced than this, which is basically tahqiq al-manat after you bring your own circumstances into the scenario. And Imam Ibn Taymiyyah actually talks about this, that each and every individual is required to make ijtihad. Because even in subtle matters, qira'at al-Quran and dhikrullah, which one is better? Then this is a discussion that will be have at a certain level of abstraction. But for the individual practitioner, they have to determine whether now, for me, now, is it better to be making dhikr or to be reciting or to be praying tahajjud? Is it better for me now to be doing this or that? That is a form of ijtihad. That is a type of ijtihad that you will have to practice, and everybody has to practice. But there is something more apparent than this from a fiqhi perspective. You want to pay your zakat, and you're looking around to see who's eligible for the zakat. That investigation is a form of ijtihad. To determine eligibility for zakat is a form of ijtihad. Is my brother, if you believe in this, and like I said before, Malikis and Shafi'is would believe that you can give your brother your zakat. Hanafis and Hanbalis have an issue with the hawashi. But Malikis and Shafi'is don't have an issue with giving your zakat to hawashi. Hawashi are side relatives, not amuday and nasab, not upwards from you or downwards, your sides. Okay. If you believe that it is allowable, and you have to make that determination, are they eligible or not eligible? Or should I be giving my zakat to, that poor neighbor or that, person across the world, or for that cause across the world, etc. That's an ijtihad that you have to make. Is this water pure for me to use for wudu or not? That's an ijtihad you have to make. What is the proper direction of the qibla? That is an ijtihad you have to make. So that type of ijtihad as well is not voided by another ijtihad. Is not voided by another ijtihad. If you exert your maximum effort in that ijtihad and you end up being wrong, it will not be voided. Okay, but we will talk about different scenarios in terms of proper sort of course of action after you discover that you were wrong. Another issue that we want so now let's talk about the ijtihad that will not be annulled. It's not any ijtihad, Some ijtihad will be annulled. And the Imam al-Khiraqi, rahimahullah, says, and he doesn't annul the judgment of another if it is brought before him. That's the judge. Except what contravenes a text of the book or the sunnah or consensus. Text of the book or sunnah or consensus. نص من الكتاب أو السنة أو إجماع. These are the things that Imam al-Khiraqi mentioned. Imam al-Khiraqi, this text of Imam al-Khiraqi is matn, not a sharh. So let's go over the sharh. And not the sharh of Imam al-Khiraqi's matn, but a later sharh. A sharh, of the sharh by al-Buhuti of Imam ibn al-Najjar's matn. Ibn al-Najjar wrote a book called al-Muntaha, Muntaha al-Iradat, and Imam al-Buhuti wrote a commentary on it, دقائق أولي النهى, في شرح المنتهى. So let's see how they basically explained this particular ruling. So we said text of the Book of Allah, the Sunnah of the Prophet, or consensus. They said in Sharh al-Muntaha, and I am saying they said why, because they're both speaking at the same time. Ibn al-Najjar has the matn, and the sharh, so this would be the matn, and then the al-Buhuti would be adding the sharh between the matn. So they're both speaking at the same time. So they said, it is forbidden to annul anything of the judgment of a judge fit for the judiciary. Fit for the judiciary. So the first basically qualifier here is what? The person is making ijtihad has to be fit for that ijtihad. Your ijtihad in taharri, in figuring out the water pure or not, everybody has to be fit for this. You have to do your maximum effort in this, because you, as an individual practitioner, you will have to be making that ijtihad. But if you adjudicate a case when you don't have any knowledge like of fiqh and stuff, you adjudicate a case like this, for instance, like al-Himariyya, and you're not fit for ijtihad, then we will void your ijtihad. Okay, so he said fit for the judiciary, lest it lead to annulling the judgment by its like, and to no judgment being established at all. Other than that, now the exceptions now. A judgment which contravenes the text of the Book of Allah. A judgment which contravenes a mutawatir sunnah of the Prophet. Or, why mutawatir? Because it leaves no room for, judging the establishment, the transmission. Doesn't leave room for judging the establishment. Or ahad, singular reports, but he says ahad, and instead of telling you which type of ahad, he gives you examples, such as the judgment to kill a Muslim for killing a disbeliever, and such as the judgment to make one who finds his very property with another, with one under interdiction for insolvency equal with the other creditors, such a judgment is annulled because it did not meet its condition, since the condition of ijtihad is the absence of text. Remember we talked about la ijtihada fi mawrid al-nas, no ijtihad is allowed when there is text. He considers these texts, and he considers these nusus. Did the scholars disagree over this? Did some scholars say that a Muslim may be killed for killing a non-Muslim? Yes, the Hanafis said that. And what is the other example that he gave here? To make one who finds his very property. He's actually given us some subtle examples where he could have used more like better examples, because he's given you examples that are a little bit controversial. He could have given you better examples for the nusus that are nusus really definitive in both transmission and implication. But he's sufficing with giving you examples of nusus that are established in transmission, even though they may not be an implication, because his intent is to show you that when we say ahad, we're not excluding ahad. When we say mutawatir, we're not excluding ahad simply because it's ahad, but because there is room for controversy over the transmission. And he will give you an example of when there is room for controversy, this will come. I'll give you an example. The example is what? La nikaha illa biwali. There is no marriage. Marriage is not valid without a wali. This report, even though we have several reports, but all those reports have issues. Issues in what? In their transmission. Their implication is obvious, but they have issues in their transmission. Therefore, he will say that this one, you do not annul the ijtihad of someone who said, who allowed nikah without a wali, because we don't have a nas against them that is beyond controversy. Because these nusus about la nikaha illa biwali, there is no marriage without a guardian, are all sort of controversial. Okay. So we have a nas from the Book of Allah, mutawatir sunnah, ahad that is established. Ahad that is established, not controversial ahad. Then he says, to make his property, like when someone is under interdiction and you find lots of things, you basically seize their property. And some things, they have purchased an item from a person and they have not paid them yet. They have purchased an item from a person and they have not paid them yet. For instance, you come to get your money from them. They are bankrupt and they owe you, they owe me, they owe everybody a little bit of money and a little bit of this. And I find my very exact property among the seized properties. Am I treated like the rest of them? Or can I take my property because I found my very property here? This is mine, this is mine. Can I take it before the division? Or should we wait and make an assessment of all the properties and then divide them proportionately to how much he owes everyone? So, if his properties would pay off 2/3 of the debts for everyone, then everyone gets 2/3 of what is owed to them. 2/3 of what is owed to them. But I found my very property. Should I get 2/3 of it, or should I get my property? We say you get your property because there is a hadith about this. This hadith is established in transmission, you know? And then we divide the rest among the people in proportion to what they are owed by the interdicted person. You know, so he's giving you examples of hadiths that are just established in transmission. Okay. Now, so he's saying that we will annul this ijtihad nas in the Book of Allah, mutawatir sunnah ahad, because there is no room for ijtihad in the presence of a nas because of hadith Mu'az. Hadith Mu'az is in itself controversial. Of course, Imam Ibn Hazm will go to any length to disprove hadith Mu'az because it establishes qiyas, analogy. So if you want to read about, you know, like critique of hadith Mu'az, you go to Ibn Hazm to basically like, or, you know, but anyway, it is, there is controversy. Although it's a beautiful hadith and we like it a lot, and you know, when the Prophet ﷺ said to him, what will you use to adjudicate between people? The Book of Allah, and then what? And then the Sunnah of the Prophet ﷺ, and then what? Then I use my own ijtihad, and I don't fall short. I do my best using my own ijtihad. It's a beautiful hadith. Everybody likes to quote it. Two people don't like to quote it. People who want to equate the Sunnah with the Quran, they have an issue with the hadith because they want to say the Sunnah has the same basically legal weight as the Quran, despite the fact that no one disagrees over the honor and the virtue of the Quran over the Sunnah in terms of honor, but in terms of legal weight, they do not want this staggered, stepwise approach. Look in the Book of Allah first, and then if you don't find, look in the Sunnah. Look in the Book of Allah and the Sunnah, they want to say. So they don't, basically, they have a little bit of ambivalence about Hadith Mu'az. They don't like it a lot. And the other people are the people who will deny qiyas, like Ibn Hazm, because ajtahid ra'yi at the end of the day is qiyas. You know. So Ibn Hazm wants to say that everything is in the Book of Allah and the Sunnah of the Prophet. Then the nusus of the Book of Allah and the Sunnah of the Prophet are enough. So he will not. But Hadith Mu'az is a popular hadith. He's saying, based on Hadith Mu'az, there is no room for ijtihad if there is a nas in the Book of Allah or the Sunnah of the Prophet sallallahu alaihi wasallam. And then he says, definitive consensus, or it contravenes definitive consensus. It's annulled if it contravenes definitive consensus. And then he points out that I meant to say definitive consensus because al-ijma' al-sukuti is different. He says that if it contravenes ijma' al-sukuti or tacit consensus, what is the difference between definitive consensus and tacit consensus? Tacit consensus is what? Ijma' al-sukuti is what? Speculative. But what do we mean by ijma' al-sukuti? It is basically when some scholars say something and the rest of the scholars, we can't quote them on it. We can't cite their position. They have not said anything about it. So we don't know if they said, you know, if they were in agreement or not in agreement, but since they stayed silent, then we will go by the people who spoke. And we will report the ijma' on the basis of the people who spoke. But we didn't survey 100% of the scholars to know, is the definitive consensus a real creature? Some people argue that it's not a real creature. There is no way to survey 100%, but that's a different issue. It will end up that it will end up that the definitive consensus is applicable only to al-ma'lum min ad-din bid-darura. Things that are known to be part of the deen by necessity, such as what? Dhuhr is 4 rak'ahs and khamr is haram. Things of that nature, things of that caliber. Dhuhr is 4 rak'ahs, khamr is haram. So most of the consensus that we report is speculative at the end of the day because it is sukuti, tacit consensus. We know some scholars said that. We don't know what the rest said or whether they will agree or not. He's saying that an ijma' that contravenes a tacit consensus, that ijtihad that contravenes a tacit consensus is not annulled. Is not annulled. That's a big statement, by the way. That's a big statement. Ijtihad that contravenes a tacit consensus is not annulled, because in order for this to be definitive, the consensus has to be a definitive qat'i consensus, not a speculative one. Tacit consensus is considered speculative. So what is the right position when it comes to tacit consensus? We consider there are 8 different positions. 8 different positions. We consider the most sort of moderate and correct position to be that it is a speculative proof that will basically wait in line, that will get into the sort of the mix. A definitive consensus will override anything else. This does not override by its own power. We will consider it. It's one of the proofs. We'll put it here, put another one here, put another one here, get all the proofs, and we will consider this to be part of the mix, the proofs that we will be examining. A definitive consensus does not wait in line, does not wait with the other proofs. It overrides, it overrules. There is no discussion. There is a definitive consensus. So we're not going to sit here and discuss whether dhuhr is 4 rak'ahs or 3. Anyway, so then what else, when else can we nullify an ijtihad? If it is contrary, if it contravenes what he himself believes at the time of the issuance of the fatwa or the decree or the judgment. If Umar radiallahu anhu, the first time he adjudicated, and hashahu taban, the first time he adjudicated the first case, he did not believe in that judgment. He did not believe that the full siblings are to be excluded from inheritance. He believed that they should take a share, but he judged contrary to his belief. His adjudication would be annulled or not, would be annulled. But since he believed at that time in the soundness of that judgment on that day, and he later changed his mind about it, and he believed that he was wrong the first time, that the second ijtihad will not annul the first one. Because on the day of the first ijtihad, he actually believed it was correct. Had he believed it is incorrect, he should have annulled the first about the second. And of course, Umar would, but some people may, adjudicate against their own belief. Okay, so then what else? He said, no judgment is annulled. He gives you some, he clarifies some things. No judgment is annulled concerning a woman, like a woman contracting her own marriage. Why? Why are we not annulling this? Because of what we discussed. La nikaha illa biwali. There is no marriage without a guardian, being a controversial report. And he says, because some of the imams, due to the disagreement of the imams about its validity. And the hadith, there is no marriage except with a guardian, regarding which what pertains to it has preceded. We've talked about the controversy over this hadith. And a judgment is not annulled for contravening analogy. That is al-Buhuti speaking now. No, Ibn al-Najjar is the one who said this. Al-Buhuti now speaking and saying, for among the rulings of Sharia are those established contrary to analogy. Did we discuss this last time? Yes. And we said that this statement in itself is controversial, because we don't believe that anything in the judgment of the Sharia contravenes analogy. But you could say contravenes the apparent analogy, the seeming, apparent, what people call analogy. Analogy like badi al-ra'i, yeah, this looks like this. But if you really examine it well, you will find consequential differences that made the Sharia give that case a dissimilar ruling, even though there is apparent similarity. But if you examine the cases well, you will find that there is a difference between ijara and sale of non-existent items, between salam and bay' ma laysa indak, selling what you do not possess. Okay, but so we will say analogy here between quotation marks, that among the rulings of the Sharia, there are those that are established contrary to, and I'm not basically putting the quotation marks for al-Buhuti. He's a great imam, and I don't want to lie, but in my understanding, I need to put quotation marks around analogy. I need to put quotation marks around analogy. So, and not annulled due to his, he says also not annulled due to the judges not knowing the disagreement. If the judge makes a ruling, if the judge adjudicates a certain case without knowing the disagreement about it, should he annul it after he gets to know that there was disagreement? No, if his first judgment does accord with the Sharia. If the first judgment does accord with the Sharia. It is also, he mentioned like an example, a judge's ruling is not annulled if he judged on the basis of the testimony of the outsider, without knowing the testimony of the insider, etc. Like, what is the outsider and insider? Outsider is bayinat al-kharij, bayinat al-dakhil. Outside, like, if we are disputing the ownership of a house, and I am here and you're here, you're the outsider, I am the insider, I have possession of the house. So this is called my bayina, or my proof is bayinat al-kharij, the outsider. This person's proof is the bayinat al-dakhil, the insider, okay? If I judge on the basis of bayinat al-kharij or al-dakhil without knowing the bayina of the other, that judgment is not nullified if the other bayina would not change the course of the, would not change the soundness of the judgment, So we will basically not void the first judgment if the second proof does not. Basically, I judged on the basis of there are 11 proofs. I was unaware of 3 out of the 11. I judged on the basis of the 8 proofs that are present on the day of adjudication. Then we came to discover 3 other proofs. Then we look at these 3 other proofs. Do they change? Huh? If they don't change the course of the case, then that's fine. Then we will not nullify the ijtihad. Okay. And that which we have said is to be annulled, the annuller is the same issuing judge. If there is a cause warranting its annulment, either the cause that's warranting its annulment is established, he annuls it as an obligation. Obligatorily, he annuls it, or does he need basically the case to be petitioned one more time, or petition of the right holder? So will I wait? So I judged between two people, and I gave the house to this person. And then when I discovered that the case should be annulled because the bayina of this person actually is consequential, I discovered that the case should be annulled. Do I need that person to basically resubmit the case or something? Or should I obligatorily annul it? Obligatorily annul it. I must annul it. I must go back and say, I was wrong. I had deficient data or information. I must annul it because it's the right of Allah subhanahu wa ta'ala. And its issuing judge annuls it if it becomes apparent that one who testified before him was not suitable for shahada, testimony, was not suitable. So he has to annul it. And if the judge does not deem the testimony acceptable, such as, this that was the father or the grandfather of another or the child of another, etc. Likewise, in every case where what he judged upon is a matter of dispute, if the judge holds an opinion by which he does not deem such a judgment valid, and later there becomes known to him something that, according to his adopted view, invalidates his ruling, he must annul it. Basically, if it is a controversial matter and you issue a judgment based on insufficient information, and then after getting to know the rest, there are two different views, two views. You believe in this, and then you believe in this view. After you collected more information, you found out that based on the view that you believe in, the first ijtihad should be annulled. The case should be re-adjudicated. Should you say, but there is another opinion that will make this case still okay? That there is another considerable opinion. No, you cannot say this, because on the day of the judgment, you believed in this, not that. You believed in this, not that. Keep in mind, I am, and this is a very controversial issue, but I am all for codification of Sharia. It's not going to work where every little court on every corner has a judge that has his own ijtihad and his own ideas and stuff like this. That can't happen nowadays. You have to understand change of circumstances. In the past, when you had like one judge in a village or something, yes, we have a Hanafi judge, we're stuck with him until he leaves, and then we get a Maliki judge and we're stuck with him until he leaves. But nowadays in large cities, you're not going to be, no civilization can tolerate this much inconsistency in rulings. Like you go around the corner, you find the Hanafi judge. You go around the corner, you find another Hanafi judge who is reading from a different Hanafi book. It's not going to happen this way. There has to be codification of Sharia, law of the land. The law of the land is based on the Sharia, but then the judges will have to go by the law of the land that is based on Sharia, not everybody's ijtihad. Not everybody's ijtihad. And it's a very, very controversial issue. And I usually don't speak with that much assertiveness about very controversial issues, but I'm very passionate about this because It's just like, it's really obvious. Yes. Of course we have an appeal. There is an appeal court in Islam, of course, yes. Because we can annul the first ijtihad by another ijtihad if we found a reason for annulment. That whole issue, that whole discussion is telling you there is an appeal court and an appeals court in Islam. Because there are cases where the first ijtihad is annulled. Yeah. So, and the judgments of one who judged, okay, this is important also, and the judgments of one who judged while unfit are annulled, even if they coincide with what is correct. Isn't that a big statement? Now, we kept on saying, if it accords with the Sharia, we will not annul it. If we find new information, but the new information will not change the course of the case, and the judgment still accords with the Sharia, we will not annul it. We will annul it if you're unfit for ijtihad, even if you are correct. Basically, to teach people a lesson. Now, what is the exceptions here? The exception is, according to their standards, and certainly the standards vary, and scholars have different standards for ijtihad. But according to some people's standards, maybe we don't have anyone fit for ijtihad nowadays, fit for being a judge nowadays. So it is called, ad-darura, necessity. So the fittest is allowed to make ijtihad, even though if he is not fit, but he is the fittest. Okay? Which is qada darura. Insofar as they coincide with the Sharia, as chosen by Shaykh Taqiyuddin, that's Imam Taymiyyah rahimahullah. For it is a legitimate appointment, otherwise judgments will be disrupted and disputed all the time. So according to the madhab, let's now summarize that very long excerpt from Sharh al-Muntaha. Summarize that very long excerpt from Sharh al-Muntaha. According to the madhab, ijtihad will be annulled if it contravenes a text of the book, a mutawatir sunnah, a had report whose authenticity is not disputed, definitive consensus versus speculative consensus, or what the judge himself believes at the time of judgment. Okay, now it will be annulled if it contravenes any one of these. 2, or it was founded upon a testimony later shown to be invalid. 3, or an error in an attribute or state upon which the ijtihad depended becomes clear. 4, or if it was issued by one unqualified to adjudicate a case or make ijtihad. And it is not annulled if it contravenes analogy, because this is contrary to the majority, by the way. Because according to the majority, if it contravenes clear analogy, it can be, particularly the Shafi'is, according to the Shafi'is in particular, if it contravenes clear analogy, it will be annulled. Or its evidence is a matter of disagreement in its authenticity or meaning, or it is issued while ignorant of disagreement or of the opposing testimony, as long as these do not affect the judgment. To these points, which we have summarized from the foregoing Sharh al-Muntaha, there is added what is also in Sharh al-Muntaha concerning ongoing rulings wherein alteration is acting upon a second ijtihad, not annulling the first. Okay, so sometimes when it looks like we're annulling the first ijtihad, we're not annulling the first ijtihad. We're simply acting upon a second ijtihad. when you, in cases of child support, for instance, if you make an ijtihad and you say child support should be $200 a month, $500 a month, whatever, changes in circumstances, in basically the person's income, make you change your ijtihad in a couple of years. Changes in, cost of living make you change your ijtihad in a couple of years. Is that an element of the first ijtihad? No. It's simply issuing a second ijtihad from here on. It's not an element of the first ijtihad. So this is our madhab. This is when ijtihad is annulled according to our madhab. According to the Shafi'is, they agree with us and they add if it contravened the clear analogy. According to the Hanafis and Malikis, they sometimes, in theory, say it's not annulled unless there is consensus, but they come back and violate that principle or that sort of rule. Imam ibn Qudama and al-Mughni mentioned a couple of examples where they themselves contradicted this rule of consensus. So Malik, rahimahullah wa radiya anhu, said if he judges the right of preemption for the neighbor, his judgment is annulled. Because your neighbor, does he have right of preemption if you sell your house? If you share a corridor or something, yes. But if everything is delineated and you have everything is delineated between you and him and you don't have something in common that you share with each other, then there is no right of preemption even though he's your neighbor. Imam Malik said, if you give the right, if you judge based on that this neighbor has a right of preemption, we will annul this. Hanafis will do that. You're annulling their ruling. Why? Because you believe that there is a text of revelation in contradiction to that. So it is not just a matter of consensus. It's not just a matter of consensus. Hanafis will do the same thing. He said, Abu Hanifa said, if he judges a sale with an omitted tasmiyah or judges among slaves by drawing lots, his judgment is annulled. Well, Malikis would say that, or Shafi'is will validate that. A sale with omitted tasmiyah. Omitted tasmiyah, like you sell like a slaughtered animal that that tasmiyah has not been named or mentioned on it. So haven't learned what anyway, but in principle, the Hanafi or the Maliki position, does it have wajaha? Does it have like an appeal, like the strength? Yes, it does have wajaha. If there is no consensus, we will not annul. If there is consensus, we will annul. It is simple and straightforward. You see how like many exceptions that we went over in our madhab, they're saying, is there consensus? There is no consensus. And makes simple, we didn't have to talk about it for an hour. Now, yeah. Yeah. فإذا وقعت الحدود وصرفت الطرق فلا شفعة. Yeah. 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 الله يبارك فيك. You live in an apartment. When you pay the rent, are you the real owner? I'm old, like my hearing. Yeah, can someone raise their voice? Yes, yes. Oh, the landlord is the real owner of the apartment. That is why the landlord is responsible for basic maintenance of the apartment. But you are the owner of the usufruct, the use of the apartment during the period that you're renting it. You're the owner of the usage, the usufruct, not the actual property. The use of the property is what you own, not the actual property. The owner of the actual property is responsible for basic maintenance. That is why if you're renting and like one of the pipes blows up, you bring the landlord to fix it because you're not the owner of the actual property. He can trespass? No, he cannot. He cannot because you own the usufruct or the usage. Okay. So having learned what of the judge's ruling is annulled, the ijtihad is broader and judgments are more resistant to annulment than other matters. Ijtihad may be undertaken by a person for himself. It may be accompanied by a judge's ruling or a mufti's fatwa or not. It may be acted upon or not. It may pertain to a grave matter or not. So all of what we talked about here, and I'll try to finish in 10 minutes, but I'm not going to go over the next qaida. But all of what we talked about here was what? Court cases, adjudication by a judge. Is ijtihad limited to court cases? No. We said there is an ijtihad of a mufti. There is your personal ijtihad. There is ijtihad that you acted upon. There is ijtihad that you didn't act upon yet. There is ijtihad pertaining to a grave matter, like marriage. There is ijtihad that's not pertaining to a grave matter. There is ijtihad that's pertaining to the rights of Allah. There is ijtihad that's pertaining to the rights of the people. Is that all treated equally? No, it is not. Okay, so let us go over this. If one exercises ijtihad for himself, then his ijtihad changes, he must annul it. We do not want basically inconsistency and disruption of judgments in court cases. But if you make ijtihad and you change your ijtihad, you annul your first ijtihad. An example on this, if you marry without a wali, based on your ijtihad, and then your ijtihad changes, you are a mujtahid. You are a mujtahid. It's not like you're a mustafti. You are a mujtahid. Keep in mind, you are a mujtahid. You're getting married. You married a woman without a wali because you are a mujtahid. You are a real mujtahid. You're not just an imam of a masjid. You are a mujtahid. So, and then you marry a woman without her wali based on your ijtihad as a qualified mujtahid. You change your ijtihad afterwards. Must you annul your first ijtihad and remarry the woman? The mu'tamad of the madhab is, yes, you must. But it's an issue of disagreement. It's an issue of disagreement even within the madhab. However, you're not obliged to redo what you have done according to your first ijtihad. So you prayed like in your home, you prayed to the Qibla, you did your best, you did your ijtihad, and you've been praying for a couple of years to this side. And then you discover the Qibla is this way. Yeah, should you repeat 2 years of prayers? No, you don't have to. But again, this is an act of worship. وَحُقُوقُ اللَّهِ مَبْنَاهَا عَلَى الْمُسَامَحَةِ. حقوق Allah are based on leniency. But what if this, your first ijtihad pertained to a dispute between you and your business partner, and your second ijtihad leads you to believing that you shortchanged your business partner and you owe them like $10 million. You have to return the money to them. You can't say, well, this is based on my first. No, you have to annul your first ijtihad if you discovered that you were wrong. If a judge exercises ijtihad, then his ijtihad changes. The first ijtihad is, so this is one side. You're exercising ijtihad for yourself. You're exercising ijtihad for yourself because you're a mujtahid. Or because it's a matter where you, like the qibla, you don't have to be the mujtahid in the technical sense. You're licensed to make ijtihad regarding this matter. You exercise ijtihad and then you discovered it was wrong, you must annul it by default, except in certain cases you are not going to redo the acts of worship and so on. But the default here, annulment is the default. A judge in the court, the default, what? No annulment, because we want, courts to have some haiba, what is haiba? Like an aura of reverence and stuff in the hearts of people. And if rulings are changing all the time, the courts will lose that aura of reverence. Okay, but something in the middle between making ijtihad for yourself and being like a judge in the court. A mufti and a mustafti now. Fatwa, not judgment in court, fatwa. Between the two ends, if one exercises ijtihad and gives a fatwa, then his ijtihad changes. Is he obliged to inform the mustafti? Is the mustafti obliged to revert to his second ijtihad? What if the mustafti has already acted upon the first ijtihad? And what if he married upon the first ijtihad? Okay, so let's go over this quickly. If the first ijtihad is of the sort whose judgment is annulled, then annulling the fatwa is more fitting. So if the mufti gave a fatwa, and that fatwa would be annulled even if it was a court case, then to annul a fatwa is even easier than annulling a court case. So a mufti that gave ijtihad that is contradictory to a nas in the book of Allah, the mutawatir sunnah, contravenes consensus, etc., that fatwa will be annulled, of course, because we said that even if it were a court case, would still be annulled. The mufti must inform the mustafti of the change in his fatwa before he acts upon it, not after he acts upon it. So if you come and ask me a question, and I give you a certain fatwa, and then I change my mind the next day, I have to call you back and tell you, I changed my mind. But I'll ask you, did you already do that, like musibah? And then, if you say, yeah, I did it, I just left you the masjid yesterday and went and did it, then I'll just stay silent and just let you be blissfully ignorant about it. But if you, before you act upon it, I have to tell you, I changed my ijtihad. Okay. It's not lawful for the mustafti prior to acting to imitate the mufti if the mufti changed ijtihad. Now, you didn't act upon the fatwa. I called you the next day. I told you I changed my fatwa. You can't say ijtihad is not annulled by ijtihad. I'll take his fatwa yesterday because the very person changed their mind and you haven't acted upon it yet. As for after acting upon the fatwa, the mustafti is not obliged to revert. The mustafti is not obliged to revert. And if he married by the fatwa of a mufti, then the mufti's ijtihad changed. His wife does not become unlawful to him according to, according to Abu al-Khattab and al-Muwaffaq and al-Tufi and so on and so forth. The Tufi mentioned that there may be a difference between marriage in particular and other cases. Marriage in particular and other cases. where we do not annul the marriage because of the sacredness and sanctity of marriage, but we may annul other cases. Furthermore, what we have mentioned regarding the non-annulment of judgment holds likewise in ahkam al-sultaniyya, governmental rulings. So, like we said, the Khulafa al-Rashidun did not annul each other's rulings or fatwas, and so Banu Taghlib, when Banu Taghlib were Christians, but they were Arabs, Christian Arabs. And when Umar asked them for the jizya, they said, we're Arabs, we don't pay jizya. He said, you're Christian, you pay jizya. So they kept at it until they told Umar, we will pay twice as much as zakah, but call it zakah. So, you know, of course, had Cherno been there, he would have said, no, of course not, you're going to pay jizya, there's no talk about it. But Omar said, okay, we'll call it zakah. What's the big deal? You pay it. Now, will we ever be able to change it? He says, no, we cannot change it for Banu Taghlib. We can't tell them you have to pay jizya because Omar, this is Hukm Sultani, and the Hukm Sultani of Umar will not be reversed. The Hukm Sultani of a Khalifa does not get reversed by the other Khalifa, because in this case, nobody will trust Al-Ahkam Sultaniyya. And then, you know, every time we're going to change Al-Ahkam Sultaniyya. So that gives people a lot of trust in our Ahkam Sultaniyya, in our treaties, in our agreements. Ya ayyuhalladhina amanu awfu bil uqud, or you believe fulfill your covenants. So anyway, Ahkam Sultaniyya take the same ruling. They are not annulled by change of ijtihad. They are not annulled by change of ijtihad. قولوا قولي هذا واستغفر الله لي ولكم سبحانك اللهم وبحمدك اشهد ان لا اله الا انت استغفرك واتوب اليك.